Hey folks, welcome back to the Land Fixer podcast. I'm your host as usual, Logan Swanson, where we talk all things land investing, etc. I have a really awesome guest that I think you guys are going to like today, Paul Deloughery. He is a probate attorney out of, where is he
I'm in
again?
Phoenix, Arizona.
Phoenix, Arizona. All right. So that's
Yeah.
actually kind of a hotbed for land investors. So we might have a good audience there. But before we dive into it, folks, reminder, if you are interested in buying or selling land, you can do both of those things at primelandexchange.com. Whether you're looking to invest some of your money in a real asset, hedge against inflation, anything like that, or if you have land and you're looking for another disposition channel, you can list your properties on my website. If you're looking for funding for any of your land deals, check us out at www.landpartnerfunding.com. As usual, hit subscribe. If you're listening to this for the first time, you're going to love it. Only the best guests show up on this channel. We got Paul today. Paul, could you tell us a little bit about yourself and how you got into this whole probate attorney business?
Yeah. Yeah. Thanks, Logan. So, how did I get into it? I don't know. I've had a weird fascination with this area for most of my life for whatever reason. And so I started out here. I'll do it this way. So I started out doing pretty high end estate planning, asset protection planning for a lot of dentists in the Phoenix area and also nationwide. I was in a small law firm here, boutique firm, and and so we were doing planning work and not a whole lot of like doing things afterwards. Like I didn't see a whole lot of what happened afterwards and how it all played out, and so um, I left that firm and I started my own firm back around oh shoot, what was it? 2017, I think. And 2007, sorry. Time goes fast. And I I I got into probate and trust administrations and all that stuff just because I wanted to see how things actually worked in the real world instead of just planning kind of theoretically. And it's been fascinating. Uh, Frankly, I get a lot of I get most of my work from doing probates and trust administrations and litigation and helping families, resolve conflicts and all that kind of stuff. And so I guess I'm just fascinated with the mixture of dealing with legal issues and then family dynamics.
Awesome. Yeah, that's great. Well, I'm going to start at as high level as I can get with what is like a deed. What is title? So I'm always a little envious. My goal was to be an attorney, and I got out of my undergrad degree with, I don't know, B plus ish grades, and I was like, "There's no way I can go do another 3 4 years to get a JD." So I bowed out. So I'm always envious, and I always look up to
Oh,
attorneys. So good job getting through all that. It's no small feat. Um, but what I did do is my business partner, when I first started, he was an attorney and he gave me a book on property rights, I believe is what the book it was, just like this tome,
okay.
right? So I started picking through it a little bit and learning a little bit about, how deeds originated. And it's kind of a fascinating structure, especially if you look at how our country was founded. It's like, well, land was effectively taken from some folks and then
Right,
handed off to certain people as sort of like political, I don't know, like
right.
a lot of generals and stuff were kind of handed huge tracts of land here in Texas, definitely. And then from there, it was kind of bought and sold, and then these whole titles and deeds and things like that were issued. And as a probate attorney, I think you deal with that kind of a lot. So, can you give us kind of just like a brief overview of the ownership structure of real property, real estate in the country? Because I know I've sold a lot of properties to people, and then I hand them a piece of paper, and they're like, "What is this?" There's no keys for a piece of land. So, tell us
Right.
about deeds, deed structures, things like that. Wherever you want to go with it.
Oh yeah, okay. Well, interesting. So the whole idea of D's, and you were talking about the book that you were reading. So if you go back to early American history, I want to say George Washington was a surveyor. Like a lot of the founding fathers were surveyors. That's kind of it was a big thing back then, and because it. Because how do you know who owns what and all of that stuff? And so we we the the people who founded this country were placing the English form of land ownership on top of this, enormous continent. And so, they had to like square, survey things with, into
Yep.
squares and figure it all out and all that kind of stuff. So anyway, so the idea of ownership is that it has to originate from someone. And so it, basically it goes back to the United States, bought it at some point and then gave it out to this person, and then, that person subdivided it and gave this, lot A to this person, and lot B went to the kids, or whatever, and it goes on and on and on. So it's a little bit, well, I guess it's a little bit like a car title.
Mm.
Like how do you know who owns the car? You have to look at the title. And with the land, uh it's kind of like that. I mean, you look at a deed, and so the deed says, who owns it. But there's more flexibility with deeds, because you can add all kinds of provisions onto it.
Hmm.
Most people don't, but you can add a conservation easement onto the deed. You can give it to your kids, but say they can never develop the land, or like you can have say that. Your wife can live in the house, for as long as she lives, but then afterwards it goes to your kids. So you can get crazy creative with all of it. And then, in your state and mine is community property. So then you get into tax issues, and so what's on the deed uh can impact the taxes. For example, if the title is owned by two people, by a married couple, is community property, and if one of them dies, then you get a step up in basis on the whole thing. But if it's just in joint tenancy, then you only get step up in basis on the one half that the deceased person owned, and all of that stuff. So it gets a little complicated.
Yeah, and that was kind of my next thought is, here people assume, I guess maybe from an outsider's perspective, they might not think that this whole real estate thing's very complicated. Like I went and bought something from you, and I'm sure that's a very nice, tidy thing, chain of title. There's no issues ever, and someone hands it, oh, and now you're the owner, right? I found it is not nearly that simple. And there's all sorts of different ways that the ownership of a property could be in question. There could be clouds on title, all sorts of issues, and obviously there's this whole group of title companies that deal with that sort of
Mhm.
stuff. That's not necessarily you directly, but that does come up a lot, right, in probate. So tell us a little bit about sort of what is probate, and how does that tie into real estate? Why would you be on my channel?
So probate is, it's a court system. And I'm going to generalize a little bit because it might be called something different in different states. Like in New York, it's called something different and whatnot. But in most states, it's called probate court. Uh, and the probate court is, uh, generally what deals with, dead or incapacitated people. So if the homeowner died, uh, then uh, it, then most likely someone has to either go through probate, or if the house was in a trust, then it can avoid probate. So generally speaking, um, and if the homeowner is incapacitated, like maybe has, advanced dementia or Alzheimer's disease, and the family wants to be able to sell the house, then you might be going to court, not because the person's died, but because they need authority to be able to sell the house. Now that the homeowner may have signed a power of attorney that gives the authority to, for the agent to sign on behalf of them. Um, but powers of attorney are strictly construed. So the power of attorney, and this is the general rule, might be different in your state, but in most states, I believe, they're strictly construed. So that power of attorney needs to specifically give the agent the authority to sell, transfer, convey, real estate, for example. Anyway, and if that's not there, then you're stuck going to probate court again to do either a guardianship or conservatorship, whatever it's called in your state. Here in Arizona, it's called a conservatorship, but to get the court permission for someone to transfer title.
Yeah, that's interesting. I've always thought of probate in terms of someone deceased, right? I've never really thought about it in terms of someone maybe losing faculty, like mental faculties or something like that. So the process would be going for the conservatorship. Is that what you're talking about? So say it was sudden, like someone had a head injury and they owned a home, and all of a sudden they can't
Right.
make decisions. You would have to go
Right.
to, is that the same court, a probate court that would do that, or would that go to like a family court or something?
Well, um, uh, generally speaking, it's probate court. Here in Arizona, it's probate court. I think it's the same there in Texas too. But yeah, so you have to go to probate court. Again, not for a deceased person, but to have the court appoint someone to be able to handle the real estate, financial matters, legal matters.
That's interesting. Yeah, and you mentioned power of attorney as well. That's something that you kind of hear a lot about, but I don't think people realize, like you said, is there's a strict constraint. You have to give someone power of attorney over this specific thing, and then it just doesn't apply to anything
Right.
else.
Right.
And I'm just going to kind of this isn't your exact field, but I've been playing around with this idea of partnering more with landowners to develop their properties, right?
Mm.
So say somebody just owns 150 acres somewhere, and instead of me buying the lot from them, I could say, hey, I'll give you a retail price, but we have to go through this subdivision process, et cetera. And the main hang up there is, well, what if I start putting, money in to say develop roads or run power through to add value to this property? And then when it comes time to sell, the owner doesn't show up to the title. They don't want to sell anymore because I've added all the money to improve their. And one of the things I was talking with my partner about doing this, and I was like, well, I guess we could get a power of attorney over selling those properties in this very specific circumstance from that person to ensure that they can't, after I put in a bunch of money, come in and corrupt the deal.
Right.
That's kind of an oddball operation, but that's kind of one of the ways that I've thought about utilizing that in our industry to sort of protect us in case we're in sort of one of these more complicated deals.
Yeah. Yeah, it's a good idea. And I think a typical way of going about a real estate development, like what you're talking about, would be to transfer the land to a limited partnership. That would be
Right.
your ideal thing, where you could be the general partner, the original owner can be the limited partner, and and then you can, if you go putting money into the venture, then you can have a way of readjusting for that, and um, yeah, that would probably be the way to do that, and then you could have terms within the partnership agreement about who makes decisions and who's how that's all going to happen.
Yeah, that's definitely the cleanest way to do it. We've just learned like, oh man, opening a new freaking LLC every time it's such a
Yeah.
pain. Bank accounts, paperwork, all this sort of
Oh
stuff. But
yeah.
if you're into protecting yourself, I don't really think there's a way around it.
Right.
Um, but anyways, you did mention trusts, and that's something that I really just need an education on. I've read a little bit about trusts. I think on our first call, I told you about there's some land investors in our industry that have been talking about, instead of taking a property and exchanging hands via the standard channels of, take it to a title company, sell it, etc., they would put land in a trust and then assign the beneficiary, change the beneficiary to whoever would effectively own the property in the future. It seems kind of like an odd structure, but I know a lot of people spent time developing it. So I'm curious, can you tell us about trusts, kind of how the structure works, and maybe some of the benefits around a trust, specifically in terms of maybe transferring property in the eventuality that you become incapacitated or something?
Sure. So, first of all, you need to figure out what the general concern is. If the general concern is controlling an asset during someone's incapacity or if they die, then then a trust is a good vehicle. If the idea is to uh, keep keep something in the family, you can have that, like, for multiple generations. The trust is a great vehicle for that. If it's a business venture where you're doing some work and someone's contributing money or something like that, then you're going to go selling off lots. That's more of a business transaction, is a business deal. So, typically we want to keep business issues in business structures, and family incapacity kind of issues in a trust structure. So that's typically the way to go about that. So what is a trust? A trust is comprised basically of three main roles, and then some property. So the first role, you have the person who creates it, called the grantor. It's called like, I don't know, by a dozen different names depending on who's talking about it. It can be the grantor, the trustor, the creator, or whatever. But that's the person who creates the trust. Then you have a trustee. That's the person who holds the asset, um, and manages it manages it according to the terms of the trust. Then you have the beneficiary, and the beneficiary is the person who benefits from the trust. Now, most people, when they put their home into a living trust, they go to the estate planning attorney. They want to avoid probate. If they die, and have it go smoothly to the kids. Well, that's typically just a living trust. Okay, so then if you did that, if you put your home into a living trust, you're the grantor, you're the one who created it, you're the trustee, you're in charge of everything, and you're the beneficiary during your lifetime. So it doesn't really change. It doesn't change how things happen during your lifetime. But the difference is, if you become incapacitated, you get into a car accident or something, then the successor trustee can take over and manage things for your benefit. And then if you die, the successor trustee can take over and continue managing things and distribute things according to what the trust says. So that's the main purpose of a trust. In terms of trying to buy land and develop it and all that kind of stuff, I mean, you can do it, but it's really not the best. Here's my example of it. So I have let's say I have shoot. Let me come up with a good example here. Okay, let's say you have like a Toyota Corolla, and you have a pickup. Okay, Toyota Corolla is great for going back and forth to the grocery store, okay, and going back and forth to work, good gas mileage, all that kind of stuff. The pickup is good if you want to put your dirt bike in the back of it, or put bikes in the back of it, and go out here in Arizona, go out biking around the desert or something like that. So they kind of serve two different purposes, and so you can use the Toyota Corolla to haul your boat. You have to get the trailer hitch on the back, and it's gonna heat the engine up pretty good, but it would work. But like one just works better than the other. So that's kind of my take on it.
Nice. And so you mentioned the secondary trustee. Is that someone that's pre-appointed when you like establish the trust?
Hopefully, yeah, that's the best way.
Okay.
Yeah.
And then that secondary trustee could determine who the who's the beneficiary is. They can change who the beneficiary is. They'd have that power.
Uh, Typically, no. Typically, you want that more set in stone. But you want to have some flexibility too. I mean, here's where we see things go crazy, where you're in a second marriage, and you have kids, and she has kids. Okay, and so you do a joint trust together, and the typical joint trust. Now you can change this, but the typical joint trust, if you just go to an attorney and you don't really think this through, it's going to say, well, everything goes to the surviving spouse. And if you do think it through, then you can have that more set in stone, and you can say, okay, well, surviving spouse can live off the money, but I want some of it available for after she dies, to go to my kids. But then there's other little provisions in the trust that can undermine that. There's something called a power of appointment, and so we give that to the surviving spouse so that it gets a step up in basis when the spouse dies, which is great for taxes. But power of appointment means that the surviving spouse can undermine the whole thing and still give it to all of her kids, still give it to her kids and not to yours. So there's different ways. Yeah, it does get a little bit complicated.
Oh man, yeah. I mean, that's why you have a job, right?
Yeah.
It's not
Yep.
simple.
Yep.
Okay, well, let's get back to probate. Tell us
All
what
right.
is the steps in probate. So, okay, somebody passes away, they come to you and say, the sons or the kids or whatever say, "Hey, my dad, he died. He has a will." I guess typically there's a will in place, right, for probate, or does there have to
Um,
be?
so here, let's back up. Okay,
Okay.
so someone died. You look at the deed, and you see, is the house owned in a trust? If it's in the trust, then you go trying to find the trust agreement. Okay, and the trust agreement should say who's in charge, who the successor trustee is. Okay, if it's not in a trust, if it's just in the person's name alone, then you're having to go to probate. Then the question is there a will? So you look around for the will. You find it, great. If you don't find the will, then you have to look to the state statute, and the state statute will say who's going to be in charge and who gets what, basically. And so if there's like three kids, well, they all have priority to get appointed. If there's a surviving spouse, then the surviving spouse probably has priority even over the kids. So yeah, and that's where you can sometimes come up with family squabbles. So
Yeah. And does a will have to be um like a legal document, right? Or could it
please,
just be like somebody found a napkin that said, "Hey, my kid gets all the stuff," and there's a signature on it?
please have it be a legal document. I have I have two cases going on right now. At any one given time, I have at least one case dealing with kind of an informal handwritten will. So I have one case right now with where this lady did three handwritten wills, and that actually would be fine outside of the fact that it had a whole bunch of ambiguities in it, and she was like talking smack about some of her relatives in it and all this stuff. but but that still could have worked. But then what she did is she took white out on some of the words and edited over them. So that raises a whole issue. Like, did she, because that's a revocation, but is it a revocation of that word? Is it a revocation of the paragraph? Like, what do we do with that? So the best thing is to have it be done legally, really is best.
All right, what about no will? And let's operate under this circumstance because this is most common for my industry is somebody owns a home,
Yep.
maybe that's pretty standard. But say they own three or four pieces of vacant land, all of which are less than $50,000 in value, and they pass away with no will, and they have two kids and wife. Okay, what the wife would get it right, kind of. That would be the assumption, depending on the state. Correct?
Yeah, this sounds like a bar exam question. So So, okay. So, in Arizona, let me apply
Yeah,
Arizona
do
here.
Arizona.
Okay. So you have three properties. They're each worth 50,000. Okay, so that's a total of 150. So you're over the exemption amount. The exemption in Arizona is if real estate is worth the equity to the real estate is under 100,000, then you can pass it by a small estate affidavit. But in your situation, how does that work? You said there's a surviving wife and two kids also.
Yes.
Then two kids are from the wife or from.
Yes. Say it's all one family.
Okay. Yep, one family. So in that case, uh, in Arizona, and I think probably in most states, it all goes to the surviving wife.
Right.
So
And this is where usually stuff happens, or doesn't happen, I should say. So, say there's an assumption, right? Say this person passes away and no probate is done. This is what I run into a lot, because the wife just thinks, well, of course it's mine now. My husband died, right? But maybe for those pieces of land, she wasn't on the deed, and no one generated a new deed transferring ownership to her, and then she lives her life for a while, and then she passes away, and now the kids are in the same situation, where there wasn't probate. It's just kind of all assumed.
yeah,
Um,
then you just have to do two probates, or sometimes the way we would do it is a combined probate. So the uh, in the matter of the estate of John Doe and Jane Doe.
okay, so you would then go to what, the probate judge, or you'd hire an attorney like yourself, right? And you would go to the probate judge, and say, hey, these two people passed away. All their stuff belongs to these kids, and then they would. How would they choose who gets what?
Um, yeah, well, great question. I mean, the statute typically in Arizona anyway, the statute just has it go by percentages. So, two kids, they each get 50%. So that part of it's pretty easy. Expenses get paid off the top. So, and then you have to make sure the taxes are paid and pay creditors and all that stuff. But, after it's all done, then there's going to be some amount. And okay, so typically the properties would just get sold and then you divide the money. Sometimes the kids want to maybe keep a property, so there might be some wheeling and dealing there. So, maybe the son wants to keep, one of the parcels, and the daughter says, "No, I just want the money." So you have to appraise the one parcel and figure it out and work it out that way.
Okay, well, that's kind of of chief interest to
Yeah,
me. So, say you said it's typically sold, right?
yeah, yeah,
Who goes about selling it? The
yeah.
kids don't really own it yet. Is that the attorney? Is that the court?
So, uh, it's the person appointed by the court. So, and let me clarify that. So a lot of people say, "Oh, well, first of all, a lot of people say, "Oh, well, I'm the agent on the power of attorney. I can sell the property." Well, no, if the principal, the person who signed the power of attorney is dead, then the power of attorney is no longer in effect. So you can't use that. Then they say, "Oh, well, I have this will. It names me as the executor. It names me as the personal representative, so I can sell the house." No, uh, you're only nominated to be the executor or the personal representative. You're not that until the court actually appoints you. And the statute in all states is going to say um, that you can, that's the person with priority, someone named in a will. But it could be someone else. The other sibling could cry foul and say, "Well, okay, yeah, great. Johnny's named in the will, but he's also a crack addict and is an ex-con. He shouldn't be in charge of anything." So, and then you have to go to court and try to get something else done.
So, say court. So, say in this situation, there's two kids, and they're
Yeah.
both competing. They want more shares of it or whatever. Um, would the court typically choose appoint one of those kids, or would they be like, "Hey, let's find an independent third party"?
If there is a disagreement, the court tends to like to appoint a third party, independent third party.
Is
And
that
so,
like an
so
attorney or an arbiter?
well, so in Arizona, we have licensed fiduciaries, but for people in other states, that's actually a great source. If you can get buddy buddy with some fiduciary companies, I'm not sure if it's a trust company or someone who professionally gets appointed as a personal representative or executor on estates. If you can build a relationship with someone like that, I mean, that'd be great.
Yeah, and
Yeah.
that's kind of exactly where I was going. Is I was trying to think of, all right, in these scenarios, who is put in that situation where they're like, okay, now I have to go sell 30 or sorry, a home and three pieces of
Mhm.
land in a
Mhm.
quick way, right? Because their motivation is going to be a little different, right? They might be motivated for whoever can come and buy all three of them quickly and just kind of get it done. Right. And then someone like me could come in and be like, hey, I'm pretty good at buying land kind of at a discount very quickly.
Mhm.
Um, especially with like how difficult it is to appraise land, that independent person might look at three pieces of land and really not know how to value them, or they'd have to go to a
Sure.
broker, so all sorts of stuff
Sure.
like that. So I guess the process is for you, someone comes to you, they said, hey, we need help, we need probate. What is the first thing you file? What with the who, right? Do you go to the court and you say, hey, here's what do? You carrier
Yeah.
pigeon?
Yeah. uh, you're awesome. So I can speak to Arizona.
Yeah.
Well, I think this is the way it works in most states. So there's something called formal and informal, and I'll start with the informal. So informal is when you file something with the court, and you don't have to go in front of a judge. Okay, it's basically the probate clerk or the clerk of court has checklists, and they say, okay, there's an original will, check it, it's signed, two witnesses, whatever the state requirements are, it's valid. Okay, great. Does it ask for bond? It doesn't ask for bond. It goes down the list, and then you can get appointed informally. Now sometimes you have to go formally. In the case of the three handwritten wills that I'm dealing with, well, that's formal. Okay, that has to go in front of a judge to try to interpret, try to figure out which one is valid, and do the whiteouts count and all that kind of stuff. And So there has to be hearings. You have to give proper notice and all of that. Yeah, there's different things that are filed, but I mean, anyway, in Arizona, the way it's called is if you go informal, it's called an application. If it's formal, is you do it with a petition. But the point is, one is done at the clerk of court, and one is done by a judge.
Okay, so you bring that, you file it, and then they're gonna what? Give you say you do the court route. So you have to go to court, you have to do all that.
Mhm.
You're gonna, I'm guessing, put together a packet of everything. You're like, all right, here's what we know. It's all gonna go in very nice legal format. You send it to the judge, and then there's a court date scheduled.
There's a court date scheduled. You have a hearing. At the first hearing, you figure out if anyone's going to object to what you filed. If they do, then then you're into litigation. Then we're
Hmm.
into setting a scheduling order and deadlines for discovery and requests for production of documents and depositions and figuring out what's what, and maybe they find a different version of the will that they present, and you have to duke it out. So
So you,
that part of it can take a little time. So I think what you're interested in, like, is this probate going to be worth my time or not? Is that kind of where you're getting at?
yes, kind of. I want to get a general idea of it, but then ultimately, yeah. So as a real estate guy, I'm coming in and I'm saying, all right, well, I found somebody who has a property they want to sell, but somebody died and whatever else. How do I know?
Uh, well, the lawyer's going to be able to give you a good idea of how long it's going to take. That's really
Hmm.
the best way. Yeah, you're not going to necessarily be able to judge it by, if there's a will or if there's not a will or whatever. There's not necessarily a relationship there, but yeah, for sure, get on the phone with the attorney. Figure out, and like just kind of stay in touch with the attorney. I mean, I have realtors that call me up and or email me, and it's not that big of a deal. I have a couple more emails I have to do as my process of the work or whatever, but that would be the way to figure it out. Um, and then kind of during the course of things, I mean, yeah, if it turns out to be easy, great. If it turns out to maybe take a little bit more time, I mean, just stay in touch with your contact. That's kind of the way I would do it. And don't give up. Just if it's going to litigation, I mean, don't give up on it, because your contact may end up winning. It might be a year from now, so don't like hold your breath that whole time, but stay in touch.
Yeah, and the reason that's kind of important is oftentimes we're coming in as the real estate investor and saying, we'll buy this property, and typically, so when you're buying real estate from, say, a distressed seller, usually they're not with a lot of cash on hand. So it might
Right.
not be uncommon for me to be like, hey, I'll cover the costs of this process for you. But if I don't know, so then it comes down to like, all right, well, I need to have some sort of certainty, right? So I can be like 95% sure this won't be an issue. Do you think the most obvious indicator for that would be if it's contested, or maybe you could give us some key indicators on what would make it more likely to have like a quote unquote simple probate process as opposed to a messy one?
you you need to talk to the probate lawyer and
Okay.
find out, because by contested, what's contested? Is it contested? Are there two different versions of the will? And but they both. Uh, Let me back up. There's two different versions of the will. One has daughter Betty to be in charge. One has son John to be in charge. Okay, but otherwise they go 50-50. Well, there, if your contact is going to be Betty one way or the other, I mean, you're going to get paid your expenses, out of it. But if there's a will that says everything goes to Betty, and there's another will that says everything goes to John, then you're kind of at a flip of the coin. And I wouldn't be taking a whole bunch of risks at putting money into the property. I mean, you could as a creditor, you're still considered as a creditor then. So just make sure that that's well documented and everything. But yeah, that gets a little bit messier.
What do you mean by that? Can you expand a little further on
Sure.
creditor
Yeah.
documentation, et cetera?
Yeah. Well, actually, let me ask, uh, uh, in terms of expenses that you would be putting in. So probably what you would be doing is, what is it? Let's say the loan is in arrears. It's 4 months in arrears, and so you're going to bring the loan current and then keep the loan. keep the loan current for a little bit of time. Well, you're doing that on behalf of the estate. So you are then a creditor, and you're really entitled to get paid. So at that point, unfortunately, you may have to hire your own attorney to just protect you, make sure you get paid that. And I know that kind of stinks because you're paying money to try to get money back or whatever, but that just kind of protects your interest as the investor. Or
Yeah,
so
so more likely for us, since I don't buy homes, typically there's not a loan on the property. So typically the
okay,
way it'd work is say there's a $50,000 property that I want to buy, and I'll say, hey, I'll buy it, or that might be a little low for what we're talking about. But say it's $100,000 retail value
yeah,
property, and say, hey, it looks like there's some probate work that needs to be done. I'll pay you $40,000, and I'll cover up to say $15,000 in probate expenses or something. I've never gone through this process, so I don't really know what it costs, but. That would kind of be the structure. And I'd get a purchase agreement in place with them that says, hey, I'll buy this property at this date, assuming that this is done. And then I would probably pay the attorney directly, just, whatever attorney we bring on. I don't know, can I even hire the attorney to do that directly? Or would they have to hire the attorney and then, I don't know.
um, you could pay the money
Hmm.
on behalf of your client who's the heir. You could
Hmm.
maybe do that, right? Um, yeah, just I think I would just caution you to be really careful because it's possible that there's if it's going through probate, you really want to get a handle on who's supposed to get what.
Right,
So,
exactly. And that's kind of what we would probably do is I would, find a good local probate attorney or whatever market I'm
mm,
working in and just
mm,
sit down and be like, "Hey, I'll pay you for an hour consultation. Here's all the details I know. What's the likelihood of us getting through sort of
right,
clean and quickly here?"
right,
But say it is like clean and relatively quick. I get everything seems to be very simple. There's say it's a one child, right? So both parents died. There's a single child. There's really no one else competing for interest in any of it. Um, there's a will is just never probated, right? So then is that process typically like we're gonna show up at the judge one time, he's gonna review everything and slam the gavel, and you're kind of
yeah.
done at that point? Is that what a simple one would look like?
Yeah, well, a super simple one never goes before a judge, but if you do have to go in front of a judge, then yeah, it's one hearing and you're done. And that very same day you can list a property and sell it.
Interesting. Okay.
So,
And then in that process, so we kind of talked about deeds earlier. So the say in this probate process, right? The single son is getting the property. The court agrees. Is a new deed generated and then filed, stating this
yes.
is the
Yeah.
current owner of the property? And this, what kind
Yep.
of deed is that?
Uh, well, yeah, they can be called different things. I mean, so if it's from the estate, then it's actually called a personal representative's deed. That's typically the way it's done in Arizona. I've seen other attorneys do it different ways, but really, the name of the deed is less important than what it says. So in this case, it would be, so and so acting on behalf of the estate is transferring title, to you, the buyer. So,
Hmm.
yeah, and you're talking about getting land. Uh, you know, get, I've I'd like to learn about this myself. Actually, I get phone calls occasionally from people like way out in the boondocks
Yeah.
here in Arizona, and like over the decades, people bought land like way the heck out there, and
Yeah.
then they died, and so there's why like for example, I know this is in Navajo County, but I know there's different other counties here in Arizona where there's just
Yeah.
like you know empty land, and some of it might be owned by someone, some of it might not be owned by, or maybe the owner died or whatever. So a lot of times there excuse me, a lot of times there are houses on it, and that are just empty, and people literally just go in there, fix it up, and then they kind of stay there for 10 years, and then it's theirs by adverse possession.
Yep.
And so yeah, I
I
mean
literally,
it
yeah. It's funny you mentioned this. So I have an exact sort of property like that in West Texas, 10 acre or 10 acre square. We call them desert squares in our industry. Nothing on it. Bought the property. After I purchased it from somebody, I found out that there was an adverse possession claim
Oh no.
on the property because we didn't go through. I bought it for like $1,000. I didn't go through
Yeah.
title. I did my own independent research and deeded it, but the title guy I work with didn't show this adverse possession claim.
Mm.
But anyways, I find out about it. This is the funniest thing. So I talked to like three or four attorneys, and I'm saying like, what can I do? This property's worth maybe 20 grand or something. You know, it's not worth putting any money
Right.
into to clear this up. And all the attorneys kept saying the same thing. They're like, well, have you tried talking to the person to try to clear it up? I'm like, this was filed 30 years ago. There's no way I'm going to get in touch with this person. You know, I can't even find their email, you know. So I talked to, and everybody's like, no, there's no simple way to, you have to go to court
Yeah.
to get this removed. And finally I was like, all right, I'm going to really try to find this person. And I dug and dug and dug. I found them. I called them. I sent them letters to multiple addresses. And they finally called me back last week. And they're like, yeah, whatever. We'll sign the quit claim deed and the removal. No problem. I
Wow.
couldn't believe it. Yeah. I mailed them. I should be hitting my mailbox today or tomorrow. All the documents on it. So,
Oh, wow. Well, good for
yeah.
you.
Yeah.
Okay.
Yep, not a bad deal. But yeah, it's exactly the sort of thing, right? So I buy
Yeah.
this property for whatever it was, $1,000, $2,000, something like that, and it's worth 20, maybe
Huh.
24,000. And I got the adverse possession removed for nothing, really. I found contracts and sent them and
Wow.
whatever. So that's kind of how the industry works, is you
Well, how
find
did you find out about the adverse possessor?
so I went to sell it. I went to
Yeah.
sell it to somebody for very little. I think I was going to sell it for like 8 grand or something, just because I needed money for another deal. And they wanted to close through a title company. I was like, all right, whatever. Send it to a title company. And they're like, red flag. We found adverse possession on this property.
Oh,
Um,
wow.
yep. And then yeah, three different. That title company said they didn't want to mess with it. Two other people said it was going to be way too expensive to deal with. And then I
Hmm.
found them and sent a letter and got it all cleared up.
Oh, well, good for you.
Yeah.
Yeah. Just one other thing I just wanted to add before we close. Just don't make assumptions, because I run into so many issues where people just kind of assumed that everything was fine, and and uh, listed the home for sale, got a closing date, and then a week before closing, the title company calls up with something. So, yeah. I mean, I can tell lots of stories about that. And another here, I'll tell you a real interesting story, because I know you have people from outside the U.S.
Mhm.
Listening to this. So I'm dealing with a situation where there was a probate on there was a probate here in Arizona, and uh, it included, well, not, how do I say this? There was a disagreement, and the family entered into a settlement agreement. And one of the stipulations, one of the parts to it, was that the personal representatives, or the
Mhm.
executors, were supposed to transfer land in Poland. Okay, and that never happened. The years have gone by. The years have gone by, and it turns out that Polish law is different from U.S. law. and in Poland, they don't have something called a personal representative. There is no
Mhm.
such thing. I mean, the court can appoint someone as an agent, but it's not required. So it actually it there, the title transfers directly from the deceased person to the to whoever it's supposed to go to. Period. That's how it goes. Like, there's no, here in the US, you can get a personal representative, get them appointed. They can sell the house, get the money, and then distribute it. But anyway, so the point was that, and this has been years, and I'm in the process of figuring out how to help my client actually get her properties in Poland. But we had to hire a Polish attorney to like give us the uh, kind of a summary of Polish law. I'm going to present that to the court here. They're going to say, "Oh, okay. Well, I guess this settlement agreement, obviously it doesn't work, because it said one thing, but that's not the way things work in Poland, for example." Anyway,
Right. Yeah.
so that's kind of that's a crazy example, but yeah, I have so many examples of things like that where people just think, "Oh yeah, what it should work." I had an attorney I knew used to say this all the time. "Oh well, we just rely on the law of common sense." Like, oh boy, that's not really a good way to go through life.
Yeah. Oh man, that's crazy. Yeah, that's one reason I'm glad I don't do anything internationally. There is actually, it's funny. There's a lot of land investors that do what I do, from other countries in America. So like
Yeah, yeah,
Germany, Australia.
yeah.
Actually, I have a guest Wednesday. She operates completely from Australia.
Okay.
Yeah, so it's fascinating. This industry crosses international lines.
Yeah,
I
cool.
meant to do this at the top of the hour, but can you tell folks how to get a hold of you? What sort of projects you
Yeah.
handle in Arizona? Quick little plug.
Oh yeah. Just go to probatemadesimple.com. Probatemadesimple.com. You can find me there, phone number, email, all that kind of stuff. And yeah, so pretty much anything having to do with how, how do I do this and not sound creepy? Anything having to do with like, deceased property owners or, like incapacitated people.
You find your parents dead, call Paul. It's like those guys that do the car wreck. You got hit by a big truck.
Right. Yeah.
Well, awesome, Paul.
Uh,
Your time's very valuable. I really appreciate you. Thank you so much for everything that you've taught us today. I feel like I could probably do like 2 or 3, 4 or 5, 10 hours with you. I love nerding out over some of this legal stuff. But folks, just a reminder, if you need to buy or sell land, go to primelandexchange.com. If you need help funding a land deal, go to landpartnerfunding.com. And folks, I've enjoyed you. Thank you so much. We will talk to you soon. Cheers.
Logan, thanks.